2 is on application of the bill. And well, what we have here, this bill applies to the Federal Capital Territory, Abuja, and all the states of the Federal Republic of Nigeria. My concern here is about the applicability of the law in all the states of the Federal Republic of Nigeria. I want to know if the committee is able to cross-check this with the Constitution of the Federal Republic, the schedules, to know if this is in the exclusive list, or if it's not in the exclusive list, in case of any conflict, because we're talking about real estate now, and it's a business that is flourishing across the land, and it is everywhere, all the local government areas, all the states, and of course this Federal Capital Territory, Abuja. So if there's any conflict, assuming it is not in the exclusive legislative list, if there's any conflict and whatever, was the committee able to, after meeting with the stakeholders, was the committee able to find out all these details before recommending this? That is just for the chairman to clarify. Thank you, Mr. Chairman, for the opportunity.
Of the Senate, or can I call you landlord of the Senate? Senator James Manager, even though it's correct that land is not in the exclusive legislative list, but it can also be in the concurrent legislative list, and National Assembly and State Assembly can legislate over it. And I want to also draw the attention of my colleagues to the objective of the bill. It's specified in page 2, standardized business of real estate development in Nigeria. Provide enabling environment and transparency in the business and real estate development in Nigeria. Make the business of real estate development in Nigeria conform to international best practices. Curb fraudulent practices. Ensure real estate business conform with the National Building Code. And up to the end. This is page 2. Okay, it's okay. The paper before me or in my hand is reading page 2. Yes. Okay. The essence of reading this is to let my colleagues know that we are all out to ensure that the business of real estate in Nigeria conforms with the best, practices, free from fraudulent practices, do away with racketeering, do away with land speculation and illegal practices, whether it is done in the state or at the federal level. So I agree that land is not in the exclusive legislative list. It is in the concurrent legislative list, and National Assembly has right to legislate in whatever is in the concurrent legislative list. And once the legislation is done, the law passed by the National Assembly is superior to that of the state. So I raise my case, Mr. Chairman.
Yeah, Mr. Chairman, Senator Gabriel Suswam. I think, Mr. Chairman, I want to toe the line of Senator Alero. When you have issues that borders on the concurrent list, we need to be careful. And I believe that we should pass this bill with some level of caution. And so I don't want to deviate much from what Senator Alero has said. But this is on the concurrent list. And so, Mr. Chairman, I don't think we can legislate exclusively on an issue such as this. This means that we need to go to the Constitution for us to do that. And there's no need on the issue of real estate. These are issues that state can legislate on, as well as the federal. And so I think that if there are provisions here that we infringe on that, we need to either recouch them or completely expunge them from it so that we are not guilty of trying to take over also the responsibility of state, Mr. Chairman.
The Governor East. Mr. Chairman, I absolutely agree with the submission of distinguished Senator Suswam on this. Where we find that there's a potential clash with the Constitution, it is better to err on the side of caution. So I think I'll also agree that either we expunge this particular provision or we try to couch it in a way that is absolutely unambiguous and it doesn't seem to collide with anything that will create a judicial problem later down the road. Thank you, Mr. Chairman.
Thank you, Mr. President. Yes, I would have loved to hear what Senator Ajibola, his contribution first, but let me just make my comment quickly. Ibikunle Amosun, I represent Ogun Central. Mr. President, what I know for a fact, yes, we all agree that this is on the concurrent list, that when laws, bills like this are passed, it is the responsibility of the respective states to now domesticate the bill. Yes. When they are now doing this, their domestication, of course, because it is in the concurrent list, they can now enact the bill to suit their own purpose. Yes. And I think in this instance, but I'm waiting for the lawyers, I think even if you get to court, because it's on the concurrent list, I think whatever the state passes in their domestication will probably hold sway. That is my reading of this. Yes.
Good colleagues. I think this issue is just like Senator Amosun has said. You know, it's a very important legislation, particularly given the tragic building failures that we have experienced over the years, particularly in Lagos and some other developing areas. It's very important. Now, the issue of whether it is concurrent or exclusive in this regard, because of the quality of the bill, does not arise for now. It's just like the Child Rights Act, you know, that was passed by this National Assembly. It will stand or fall, like Senator Amosun has said, on the capacity of the state to see its quality and adopt it at their own level by their state houses of assembly. So this, we should not allow on that kind of, for this innovative bill, you know, to just be washed away or wished away on the ground of whether it is concurrent or it's exclusive. So I will beg on this assembly to go ahead and pass this bill, and then it stands on its feet, you know, on its constitutional strength and the strength of the text that may be brought by whether the states adopt its content and within their own legislative environment or not. But at least we, as national legislators, would have been seen to have done our own duty and carried out our own responsibility by drawing attention, national attention, to the contentious issue of regulating the housing and infrastructure development industry. That's my case, sir.
Some of the issues that have been raised. First and foremost, it is not the case that the matter is even on the concurrent legislative list. And I want us to look at all the items listed in concurrent legislative list. There's nothing about regulation of property or real estate business. I made reference to section 4 of this bill, which is the fulcrum of what this bill is about, and that is on the function of the council. A, regulate the business of real estate development in Nigeria in consultation with REDA. Promote sustainable development of the business of real estate as championed by REDA. Mr. Chairman, the structure of our constitution, section 4, allow this hallowed chamber, National Assembly, to make law in respect of matters in the exclusive legislative list, matters in the concurrent list to the extent prescribed in that list itself, and thirdly, any other provision expressly provided for in the Constitution. Section 4, subsection 7, provide that any other matter not enumerated in the Constitution is within the province and exclusive legislative competence of the state. This has been given judicial imprimatur in the case of Attorney General of Lagos and Attorney General of the Federation in Part 833, page 1 of the Nigerian Weekly Law Report. That issue in that case was whether the National Assembly has the power to make law in respect to physical planning. The argument on behalf of the federal government was that because environment was mentioned in part 2 of the Constitution, chapter 2 of the Constitution, then ipso facto, the National Assembly had power to make law. The Supreme Court disagreed and said physical planning is a specific legislative item not so enumerated in the Constitution. I want to say, subject, of course, to the ruling that have been made, that as a matter of law, the National Assembly does not have power to make law to regulate and conduct affairs in relation to real property. Property law is domesticated in the laws of the state. And on the argument that perhaps a law will be made that will cover the field and allow the states to be able to make their own different law. This law, looking at Section 7, does not give room for that because it has centralized the regulation of real estate business in Nigeria in the central body that has been created. It is not apposite to use the example of the Child Rights Act, which is a right-creating obligation, rather than a one that is taking over responsibility of the state and their autonomy in respect to real estate and property business. I submit. Thank you.
That such money as the minister may, out of the money provided by the federal government, allocate to the council by way of subvention, loan, grant, or otherwise. I wonder where the minister will get the money from. Because the monies that we appropriate, to the ministry, unless if we are going to do it directly from here, otherwise the minister cannot have, source of funds that may be given as subvention to the council. So my suggestion is we drop this subsection E entirely.
Agreed.
That
Agreed.
Well, National Assembly, unless if National Assembly cannot put, they can get it from Treasury. But from the minister, we have to appropriate it before the minister can use it for subvention, loan, grant, and otherwise.
Thank you, Mr. Chairman. Distinguished colleagues, I'm Aliu Sabi Abdullahi. I think the point that needs to be made here is, if you look at that particular clause that distinguished Senator Yusuf made reference to, it says, yes, page 11, I guess. It says, such money as the minister may, out of the money provided by the federal government, allocate to the council by way of subvention, loan, grant, or otherwise. The issue is, while this body is established as a self-funding agency, it has certain roles linked to government. And so this provision is to see where there are situations the council may require government support. That is why this clause is made. It's not something compulsory. And it doesn't, within this context, indicate that we are going to be funding them annually. And that's why it didn't say shall. That's why it's may. If the minister does not give any funding, there is no harm. But where the need arises as a result of certain things, and they want to do that, we have not also prevented the minister from doing that, so that the main reason why this entity is established can actually be able to meet that objective. So I don't think this is antithetical to the self-funding provision. And clearly it shows that government may do that. After all, there are grants, subventions that sometimes government just decide to give. It's optional. Yes, it's not mandatory.
The Committee on Establishment and Public Service on the Real Estate Regulations and Development Bill 2021 and approved as follows. Long title as recommended. Number of clauses, clauses 1 to 40, as recommended. Interpretation, clause 41, as recommended. Short title, clause 42, as recommended. Schedules 1 to 2, as recommended. Explanatory memorandum, as recommended. Is this a true reflection of what transpired in Committee of the Whole? Leader of the Senate.
Mr. President, my highly respected and distinguished colleagues, I rise to a motion that this bill be read the third time. I so move.
Leader.
Motion as moved.
Clerk of the Senate.
Mr. President, distinguished senators, a bill for an act to establish the Real Estate Regulatory Council of Nigeria to provide efficient, effective, and transparent administration of the business of real estate development and prescribe minimum standards for the conduct of the business of real estate development in Nigeria and for related matters 2021 SB 540, third reading.
A bill for an act to establish the Real Estate Regulatory Council of Nigeria to provide efficient, effective, and transparent administration of the business of real estate development and prescribe minimum standards for the conduct of the business of real estate and development in Nigeria and for related matters 2021. Third reading taken. The bill is read for a third time and passed. Leader of the Senate.